next friend and father, Alan Hayes, and Loriana Michelle Hunt, case number 2016 DM 163. Beginning with petitioner, would counsel announce appearances for the record, please?
May it please the court, Your Honor, the petitioner, Father Alan Hayes, appears by Zoom, along with his counsel, Lacey Gilmore, appearing by Zoom in separate locations.
Thank you.
And the respondent, Lorana Hunt, appears via Zoom, and my legal counsel, Jessica Sir, who also appears via Zoom. We're both appearing from my conference room.
Very well. There is a motion currently before the court to modify residency and parenting time. My docket notes, at least, don't seem to reflect that we've ever had any type of pretrial conference or status hearing regarding this, as would be this court's policy. What is the current status of this matter, Ms. Sir?
Well, I filed this motion, and Mr. Hayes had a previous attorney that withdrew, and Ms. Gilmore recently entered into the case on his behalf. I assumed today that the court was either going to order domestic conciliation or schedule it for pretrial and trial. The parties did domestic conciliation back in 2022, Your Honor, ordered domestic conciliation in February, and there was a whole lot of delay by the petitioner in the whole process. He didn't pay fees at the end, so the report was held for a long time, and I had to file a motion to compel him to comply with paying the fees to get the report released, and so that report didn't get issued until April of 2023. So the process took over a year to my client's detriment. The recommendation gave her significantly more parenting time than the previous order, and she went a whole year not being able to exercise that more time. So I think she's a little hesitant because of that experience to agree to domestic conciliation or to ask the court to order domestic conciliation, because she's again seeking to expand her time. Dad doesn't want it to happen, and so she's concerned that it'll drag on again like it did last time and take a while. And so our request is for the court to issue, schedule it. I don't know if you want to, if we need to do a pretrial hearing, or if we can have a deadline to file pretrial conference orders and go ahead and schedule it for evidentiary hearing. I think that would be, however you want to handle that, I guess, with the scheduling is your prerogative, obviously. My client has the child share time during the summer, every other weekend during the school year. The paperwork with the school doesn't allow my client to pick up the child at all because of how Dad has done the paperwork. And she doesn't normally need to for her parenting time, but if she needed to take the child to a medical appointment, or there's a therapy appointment tomorrow, or if there's an emergency, she's not even listed as parent. And so that's something that I think she'd like to try to get, she's listed as parent. She's not listed as someone that's able to pick up the child from the school. So I know that's something that she was hoping that we could rectify today. But I'm open to proceeding how the court wants us to with regards to scheduling. And obviously, if the court orders domestic conciliation, my client will participate, but I do understand her hesitancy at this point in time.
Ms. Gilmore, what is Mr. Hayes' response?
Thank you, Your Honor. He's absolutely opposed to expanding mom's parenting time at this point. I agree with counsel that they disagree on whether that should occur. A large part of the delay in the DC recommendation was because mom has had an unstable work history, and so my client had to pay for most of, if not all of, that domestic conciliation. It was a substantial sum of money, which he did pay, and the report was released, but it took him some time to be able to pay that, particularly because I don't believe he was receiving child support or any sort of assistance in caring for the child where he was the primary custodian. I believe in the DC order, the report that came out in April of 2023, the parties agreed to attend some sort of alternative dispute resolution before even filing a motion like this. My client is fine with attending some sort of domestic conciliation, alternative dispute resolution. We don't really have LPC anymore, but he is not opposed to that. I think these parties have been successful in the past, coming to agreements with the assistance of a neutral third party. I will tell the court the DC recommendation in April of 2023 indicates that it doesn't have to be a formal dispute resolution coordinator or a domestic conciliator that guides the parties. It does make a provision for the possibility of some sort of a trusted third party trying to assist them. They don't agree on a lot of things, but typically they come to an agreement in domestic conciliation. My client's not opposed to that. He will cooperate with that. It's my understanding that mom has 3 jobs at this point. I believe she's working full-time at Home Goods, doing a wedding catering business on the weekends, and then there's an additional job that she has. She's also in school. We don't know what for, but she's also attending school. So there shouldn't be the same financial constraints we had before if the parties are equally sharing in the cost. As to the school situation, my client didn't do anything but give the school the documents, the legal court documents. I don't know why the school would prevent her from picking up the child if that needed to happen. I think she's definitely listed as a parent. I think, in fact, the parties did the enrollment paperwork together. It's my understanding that my client and mother and my client's wife sat down together and did the enrollment paperwork for the child all together. So I don't know what the issue is related to the school, but generally they communicate about appointments. My client has been the one taking the child to the appointments. I don't think that's ever been an issue, but her parenting time, as the order states, starts at 6 p.m. So there would be no reason for her to pick the child up from school. That's never been modified by the court. I don't think they've ever talked about changing that. So he didn't ever tell the school, hey, she can't pick these children up. I think they're just interpreting the order and saying, well, you don't need to pick them up or pick the child up after school. We're talking about a child here that it's just about 10 years old. So she's certainly old enough to know, hey, this is my mom. She's here to pick me up. So I don't know what the issue is with the school, but mom is listed as a parent. They did the enrollment paperwork together. My client did nothing but provide whatever the court order is. So we're not opposed to DC or some sort of ADR. I think it's probably required under the statute. These parties have never had a trial. These motions have been filed back and forth by one parent or the other. They've gone to domestic conciliation or ADR and they've reached an agreement. So we have no reason to believe that wouldn't be the case now. And he's not opposed. We'll proceed however the court directs. If we need to have a deadline for filing pretrial conference orders or questionnaires, that's fine. We have no issue with that. Whatever is convenient for the court, we are willing to do.
If this court were to consider some sort of ADR in this case, who would you suggest the person be to conduct it, Ms. Gilmore?
I guess what I would ask, Judge, would be if the availability of someone maybe who's on a sliding fee scale, if that's an option, if there's something, that's providing this sort of service there, I think that would be a fair possibility for these clients so that they could both come up with the needed financial investment for that to happen. Alternatively, I don't think either of these parties is living in Butler County currently. They're both living in Wichita. So, and they have been, I think, for quite some time. There may be someone on the list in Wichita that the parties would agree to. I've had good success with Jessica Sherwood in the past, or Diane Sherwood. She uses some sort of revolutionary method that delves into forgiveness. So I've had good success with her. I don't know what counsel's position would be on that, but that's who I would suggest.
But sir, I'll ask you the same question. If this court were to consider ADR, who would you propose the court utilize for this service?
Sure. If the court were to order ADR, and I would like to clarify that the last domestic conciliation, there was 3 or 4 memorandums that were circled that Dad never would agree to ultimately sign. So it went to investigation and a report and a recommendation was issued. It then wasn't objected to by either party, but I think it's not accurate to say they reached an agreement in domestic conciliation. There was a recommendation that was made because they could not reach an agreement. Midland Mediation in Wichita has a sliding scale for mediation that's very low income, but Dad's made it clear he doesn't want to expand her time at all. So if he's not going to budge from that position, I think we'd be at an impasse in mediation. Diane Sherwood does not have a sliding scale. She's probably as expensive or more expensive than who the court appointed, Melissa Meyer and their office in the past. And so, I have worked with Diane Sherwood on cases and had her do recommendations and reports. I don't know that she's necessarily the most detailed, and I think detail does help these parties. So I'm not opposed to using someone in Wichita versus using Collaborative Success, who you normally use. But I am opposed to a process that's going to drag on for a whole year. So I would say let's try mediation at Midland, but also go ahead and proceed with scheduling a pretrial conference and a trial. And if they reach an agreement, that's wonderful. But if not, I don't want this to delay my client having access to being able to expand her time, because I think it's warranted.
How do you know what Mr. Hayes' position is on possible expansion or modification of the current parenting schedule?
Well, Ms. Gilmore just said he was absolutely opposed to expanding her time. I mean, she was pretty adamant in her statement, but he's also communicated to my client that he doesn't want her to have any additional time.
Ms. Gilmore, is that indeed your client's position?
Judge, I don't know that he's opposed to expanding her time, but he is opposed to giving her shared on a 50-50 schedule that's requested by counsel's motion. And that's based upon the history of this case. Mother's had a lengthy history of profound instability.
Which she doesn't have at this time and hasn't for quite a while. She did it a long time ago.
This court is of the opinion that some sort of alternative dispute resolution should be attempted in this case before the matter is again tried. So the court at this time will order that the parties participate in mediation with, is it Midland Mediation Services?
Yes.
Who would be the principal people that would be operating for that business?
Joy Marlin is who does it, and it's under an umbrella funding that somehow is tied to Kansas Legal Services, which is why they have a pretty reputable sliding scale.
So on sliding scale, do they look at the individual resources of each of the two parties independently and determine an appropriate amount for that party to pay?
Yes.
All right, because I would generally expect that the parties would do some sort of sharing, obviously, of this cost.
It's a sliding scale, and what I don't know off the top of my head is if one person qualifies, if they then make the other person pay the same amount, but they do look at their incomes and determine what's appropriate based on their income. But it's a lot cheaper than other mediations, at least here in Wichita.
All right. Expected time frame for this process to take place, since I think Ms. Gilmore will immediately journalize what we're doing here today and get the mediation process started, at least through the drafting of the order. What is the expected time frame here?
I mean, I think that they generally can get people in. It seems like within 3 or 4 weeks, there's an appointment, and they're pretty quick if there's an agreement to draft a memorandum. So I would say if we can get the order over to her soon. I mean, obviously there's Thanksgiving and Christmas coming up, which kind of throw schedules a little bit off. But I mean, I would think that if we can get the order to her soon, she ought to be able to meet with them sometime in December, would be my hope.
All right.
My best guess, Judge, would be around 60 days. And I think that would be fair because the parties will need to engage in discovery if we're doing this sort of two things at once. If we're proceeding down a trial track and then also doing the mediation in hopes that they reach an agreement, there will need to be some discovery that occurs.
Such as?
Interrogatories to mother and notice of business record subpoenas.
Who would the business record subpoenas be directed to?
Well, I think there's an issue. Judge Mother has been on in ongoing mental health treatment for some period of time, which is relevant to this case. There are also 2 arrests that Mother has had for domestic violence related offenses that would need to be obtained. Additionally, there would be some school records that are necessary, as well as employment records, to be able to demonstrate to the court with exhibits Mother's pattern of instability.
All right, I will ask my assistant for an appropriate status conference date in late January, maybe toward the beginning of February. That should allow this 60-day process to complete and give us a little bit of buffer time. before we actually bring the matter back before the court again. Mandy, I can't, if you're talking, we can't hear.
Can't hear me?
I can now.
Okay.
Go ahead.
The last week in January is our docket week. Would that be okay to place on there?
If you have a time slot available, yes.
Okay, how about the morning of January 28th?
That works for me.
That works for me as well, Your Honor.
What time, Mandy?
Let's do 9 a.m.
9:00 a.m. on January 28th. That'll be by Zoom. I encourage the party's attendance. Obviously, counsel for each party must appear by Zoom at that time, January 28th, 9:00 a.m. Counsel, I think scheduling a trial date is premature. I really want to encourage the parties to reach success, on an agreement between now and January 28th. We'll determine status on January 28th and go forward from there. And I don't think, Ms. Sewer, this is going to linger in the system for a year.
Nope, I agree with you. If we've got a status conference, I'm pleased with that.
All right. I will expect the parties to make immediate arrangements once this mediation is set up, that we expect the parties to participate in good faith and schedule as early as possible under the circumstances. Let's get this process moving and let's start talking to one another about a solution. All right. Ms. Gilmore, is there anything from your perspective that the court currently needs to address?
Just for clarification, Judge, I have no problem journalizing the order for today's hearing. Do you want me to do a separate order for mediation, or will the court's assistant handle that specific order?
Include all of it in one order, Ms. Gilmore.
Yes, will do.
Okay. All right, Ms. Sewer, anything else that we need to address at this time?
Not today, Your Honor.
Very well then. Thank you all for your timely participation. Good luck. I hope the parents can talk about what's in the best interest of their child and reach agreements accordingly. If there's nothing further, this matter will currently be in recess. This meeting may be ended for all at this time.
Thank you.